The Bharatiya Nyaya Sanhita 2023 replaces the Indian Penal Code, a statutory framework that had governed property offenses for over 160 years. For a law student facing the Semester 2 examination, Module 4 requires more than memorizing section titles. Rote learning fails when the examiner moves past definitions and into application. Look at these situational questions from the exam paper. These fact patterns test a specific skill, identifying the exact moment one criminal classification legally escalates into another. In these patterns, the physical act of moving property can result in 3 different charges, depending on a single variable: how that movement was achieved and exactly when the owner's consent was bypassed. Sections 303 through 350 must be analyzed as a continuous, interactive spectrum of law rather than isolated legal silos. To secure distinction-level marks, we will map these variables onto the examiner's matrix. We evaluate 4 crucial intersections: the presence of consent versus fear, the application of violence and numbers, the boundary of lawful and unlawful, and the metrics of documentary intent. Mastering these intersecting variables is the only reliable method to avoid mischarging an offense when grading a complex judicial fact pattern. We begin with the baseline property offense, theft under Section 303. This statute exists primarily to protect possession. Reading the explicit text within Section 303, the actus reus requires the offender to move movable property out of a person's possession entirely without their consent. Importantly, the completion of this offense does not require the permanent deprivation of the property. The precedent in K.N. Mehra v. State of Rajasthan confirms that even temporary dishonest deprivation of property satisfies the statutory requirement for theft. We contrast this with extortion under Section 308, where the core mechanic of acquisition shifts from taking to delivery. While theft operates by completely bypassing the victim's consent, extortion forces the victim to manufacture that consent by applying fear. This highlighted text in Section 308, subsection 1 defines the trigger. The offender must intentionally put the victim in fear of injury in order to induce them to deliver the property. The statutory illustrations for Section 308 clarify that this fear of injury covers a wide spectrum, from threatening to publish defamatory statements to threatening physical harm to the victim's child. The distinction is mechanical. Identifying whether the victim physically handed over the item or if the offender took it without asking dictates the fundamental charge on your exam. Robbery, defined in Section 309, functions as an aggravated state of property crime. It is not an independent act, but an escalation of either theft or extortion. The single variable that triggers this escalation is imminence. Theft becomes robbery if violence is used during the theft or escape. Extortion becomes robbery if violence is threatened during the inducement, and the offender is physically present, capable of executing the instant harm. Dacoity, under Section 310, represents the ultimate aggravation of property crime, based entirely on the number of perpetrators involved. This text block establishes the rule of 5. If 5 or more people conjointly commit or attempt to commit a robbery, every single participant is charged with dacoity. The implications for sentencing are severe, escalating to the death penalty or life imprisonment if a murder occurs during the commission of the dacoity. When analyzing a fact pattern, a prosecutor must count the perpetrators to check for dacoity and measure the distance between offender and victim to check the imminence requirement for robbery. Moving away from physical force, we analyze criminal breach of trust and cheating. These are crimes of deception and violated confidence. The defining axiom for criminal breach of trust, or CBT, is that the offender's initial possession of the property is completely lawful. This lawful possession is based on entrustment. Under Section 316, the victim voluntarily creates a fiduciary relationship with the offender regarding the property. Reading the text of 316 subsection 1 and relying on the landmark case of Dalmia Cement Limited versus State of Delhi, there must be a clear legal entrustment that is subsequently followed by dishonest misappropriation. We contrast CBT directly with cheating under Section 318. Here, the initial state of possession is unlawful because it is achieved through active deception. The actus reus of cheating requires the offender to deceive a person to induce them to deliver property they otherwise would have kept secure. The ruling in Shri Bhagwan versus State of AP dictates that fraudulent misrepresentation must exist at the very inception. On the timeline of intent, acquiring property lawfully, then stealing it, is breach of trust. Having dishonest intention from the start is cheating. The precise timing of the offender's dishonest intent dictates exactly which BNS section governs the prosecution. Finally, we shift from the theft of physical objects to the corruption of legal documents, covered under sections 336 and 337. Creating a false document is only the first ingredient. The physical act of alteration does not, by itself, constitute forgery. The statute requires a mandatory mens rea, the specific, provable intent to cause damage or injury to the public or to any individual. Applying the ruling from Sheila Sebastian v. R. Jawaharaj, making a false document without the explicit intent to have it acted upon as genuine fails to meet the threshold for forgery. This is the dual intent test. The document must be demonstrably false, and there must be a deceitful intent to cause harm. Both circles must overlap. Document offenses in the BNS prioritize the offender's ultimate deceitful goal over the technical accuracy or inaccuracy of the forged document itself. To summarize our primary directive for Module 4, every property crime is defined by its specific boundary variables, not by its surface-level similarities to other offenses. Reviewing our examiner's matrix, boundaries map across these quadrants. For exam questions, execute a 3-step verification. Check timing of intent, determine consent, and count perpetrators. Passing requires identifying the section. Distinction requires naming controlling precedents like K.N. Mehra and Sheila Sebastian. A rigorous approach to the BNS Bare Act requires viewing the text as a set of logical conditions that must be met sequentially to sustain a charge. By mastering these intersecting thresholds, you move past simply memorizing the law and begin practicing the analytical precision required of a legal professional.